Hello, and welcome to Natasha Explains It All. Today, we are going to get into part 4 of my criminal court series. Last time on episode 3 of this series, we talked about pretrial supervision, and I want to pick up there, talk a little bit more about that before getting into the next topic. So, to recap a little bit, we've talked about arrest, person going to jail. Then, most likely, to get out of jail pre-trial, they had to post some form of bail. And if they were able to post that bail while they're released, the bail isn't enough. They're also likely to be subject to a variety of conditions that often include things like drug testing, curfews. If they're on electronic monitoring, which is like those ankle monitors, there's also going to be a geographic restriction, might be a house arrest situation. They will likely have to check in with some type of pretrial officer. There's also restrictions regarding consumption of alcohol, drugs, even for things that are lawful for adults to do, like drinking alcohol is legal for adults to do, but it's a very common pretrial condition that it becomes unlawful for you to consume alcohol, even though you haven't been convicted of anything. Um, so those are some of the very typical kinds of conditions that you would see. And on top of all of that, um, defendants often have to pay for all of those conditions. They'll have to pay for the supervision, they'll have to pay for the drug testing, they'll have to pay for breathalyzers, they'll have to pay for the ankle monitor. If they are required to have an interlock device on their car, which is a device that you have to blow into for your car to start, also have to pay for that. And if you can't pay, well, then you go back to jail. If you violate any of these conditions, including just missing an appointment with your pretrial officer, you can go back to jail. Now, imagine that if you're in your normal life, of like missing a meeting at work or missing a doctor's appointment or something, and going back to jail as a result of that. In the criminal court world, any type of what they call non-compliance can result in you going back to jail. Criminal courts are all about compliance. That is a buzzword. It's not about public safety. It's not about helping address whatever social needs may have brought you to have contact with the criminal court system. It's about making you comply. It's about making you compliant to whatever conditions the court comes up with. And how do these conditions get assigned? So, when someone is arrested and jailed, the first court hearing that they have is it has different names depending on where you are, but it can be called the arraignment. It can be called the bail hearing. It can be called your first appearance. But at that hearing, that's normally when these conditions are set, normally speaking. And so we talked about how when the person is arrested before they have their first court appearance, oftentimes they'll have the opportunity to get out of jail even before that first court hearing based on the bail schedule, which is just a list of dollar amounts that correspond with the charges that the whatever the relevant policing agency is came up with. Um, and if you can't post that bail, or if you aren't released before your first court appearance, at that first court appearance, that's normally when the judge will set a new bail amount, and then also specify what conditions you will be subject to if you are released. The judge also has the option to release people on their own recognizance or personal recognizance, which I know we talked about in a prior episode. But essentially, if you are released pre-trial, it's very likely that you are going to be subject to a series of additional conditions that you must comply with. Otherwise, you're going back to jail. Even if they're things that aren't criminal behavior, for example, missing a meeting with your pretrial officer or not being able to afford a drug test. In many places, if you show up, let's say one of your pretrial conditions is drug testing, and you show up to do your drug test, if you don't have the money, they won't test you. Now tell me how that promotes public safety if they're claiming, right, that the person needs to drug test, to make sure that they're not using, and the but they don't test if you don't have the money, right? Um, and oftentimes, judges won't explain to defendants that these conditions have cost and that they must pay for them. And the judges won't explain that there's cost associated with them and won't evaluate whether the person has the ability to pay for these fees, which can be astronomical, into the hundreds of dollars per month. And as we talked about in the prior episode, these fees are not credited in any way or refunded if you are acquitted or your charges are dismissed. Um, and so, pretrial conditions for people who are able to get out of jail pretrial are extremely common and are extremely burdensome. They're also not evidence based. There's basically nothing in terms of services, quote unquote, services that criminal courts provide that are evidence based. And oftentimes, I mentioned this in the prior episode, like even for things like the drug testing and breathalyzer tests, like the staff who are conducting them, they're not trained in like how to actually read these. Um, and there's like they're not going based off of evidence that like checking in with a pretrial officer on a monthly basis is promotes public safety or promotes accountability from the person, because they already have court hearings they have to go to. They may also already be having to check in with their bail bond company, because we talked about before, they may be on a payment plan with their bail bond company because they couldn't afford their bail bond in one go. And so it's a bunch of conditions that aren't necessarily tied to evidence-based practices, that this promotes public safety or that this is an effective, way to promote whatever, accountability or something. They're just done as a matter of routine. And they make a lot of money for both governments as well as private entities, because oftentimes governments will contract with private companies to provide these services. And if people can't come up with the money, they'll throw the people back to the courts, throw the people back to jail. They'll call the police on people and have the people arrested for no other reason than they can't afford whatever it is. Oh, which also reminds me of a very common pretrial condition as well, is that people maintain employment, which is wild given that pretrial agencies, I haven't seen this. Maybe it exists somewhere. I haven't seen pretrial agencies that proactively provide social services. Some public defenders' offices will offer their own pretrial supervision programs where they have social workers and case managers that will help people address whatever their needs are that may have led them to have contact with the criminal court system. But I haven't seen that from like standard pretrial supervision offices, and certainly not from any of the private companies that contract with governments to provide pretrial supervision. So, on this employment question, for example, so the court is requiring you as a condition of your release to maintain employment. And if you don't, you can go back to jail. However, the pretrial agency is requiring you to do things that make it hard to hold down a job. For example, having to report in person during business hours, having to drug test on random days so you can't predict and like schedule ahead of time when you have to go. May have to wear an ankle monitor, which could cause problems for you at work because it can go off. It's bulky, like it's not it's not a discreet thing. And many people end up losing their jobs trying to keep up with and comply with the burdensome requirements of pretrial supervision. And at the same time, pretrial supervision offices aren't helping people find employment, aren't helping people secure employment, aren't helping people um, be able to stay on top of any jobs that they currently have. There aren't additional services offered either. For example, I this could be its own series, but a lot of cases honestly stem from, well, not just poverty um, and addiction issues, but also like a lack of skills when it comes to conflict resolution and anger management. Because there are a lot of like interpersonal issues that people end up calling the police for, because they just don't know what else to do when they're having an issue with a loved one. And the police, all they do is just arrest people, when actually what the people involved could really use is some counseling, and some skill building, and some conflict resolution, and building their emotional intelligence and wherewithal, and providing them with resources. And that's not the focus of pretrial supervision. The focus of pretrial supervision, as I said before, is compliance, and it sets you up for so many traps. Um, and any falling into any of the traps means you can go back to jail. And um, another weird aspect, but very common aspect of pretrial supervision. Again, you haven't been convicted of anything, but there are massive restrictions on your freedom as your case is, as your case is pending. Another thing that is very common is that like pretrial agencies will facilitate you admitting to additional criminal behavior without advising you of your rights. You're not Mirandized. You aren't told about your Fifth Amendment right against self-incrimination. So you don't have to incriminate yourself by admitting to criminal behavior, not providing a lawyer in these circumstances. And what I mean is that drug testing, for example, is a very common pretrial condition. And oftentimes, pretrial officers will just straight up ask people, like, where have you used? How's your drug test going to come out? Is it going to be dirty? And the reality of that is that, the consumption of drugs not only is one of their conditions, right? They're not supposed to consume drugs as part of their pretrial conditions, but depending on the drug and where you are, like that in itself is a separate crime. Um, and so it's such a common thing, like for pretrial officers to basically get people to admit to criminal behavior without providing them with counsel, without advising them of their rights beforehand. Um, and they'll even have people sign admissions, sign forms, saying like, yep, I admit that I, used meth or whatever on such and such date. And then that gets sent to the court and the person gets reincarcerated as a result. Like, how does that help anybody? The logic from the pretrial services agency and the court is certainly going to be that, well, using drugs is dangerous and we don't want people to be using drugs and we want to promote honesty. So if the person is admitting that that they're using, well, they need to be held accountable for that because they were told that they're not supposed to use drugs, period. And not only does this completely ignore pretrial defendants' legal rights, including their Fifth Amendment right against self-incrimination, but it's also completely unrealistic. A lot of people have contact with the criminal court system because they're struggling with addiction issues. And asking someone to go cold turkey, I am not a I am not a specialist in addiction issues, but my understanding is that cold turkey is not a very effective approach. Particularly, as we've discussed before, these pretrial officers are not trained in these issues. They're not addiction counselors. They're not counselors of any stripe. They're just basically other versions of cops who are here to just to be on you and to snitch on you to the court if you mess up. And so the idea you would that the only thing you would provide is a stick and no carrots, no counseling, no treatment, no support systems whatsoever, and then punishing people and violating their rights in the process by getting them to admit to use and not advising them of their rights that they don't need to admit um, to criminal behavior. Um, is really backwards. It doesn't help address if there is an addiction issue. It doesn't help the person address their addiction. It's a very like scared straight approach, which doesn't work. And we know it doesn't work because recidivism rates in the United States and drug use rates are extremely high. And we know that actually preventative measures like safe use sites, like where people can safe injection sites where people can, like, for people who use heroin and other types of injectable drugs, where they can be supervised and seen by medical professionals that can help them um, manage their addiction, as well as other support services like Alcoholics Anonymous, um, or methadone clinics and things like that. That's not what pretrial service agencies are about. They've just got this checklist of like, don't do this, don't do this, don't do this. And if you do any of this stuff, you're going back to jail. And, you know, we talked about in an earlier episode about the various um, problems that happen when someone is detained. And adding on to this, if they were going to any type of treatment, if they had any type of support system while they were out, if they were on methadone because they're trying to address their addiction and get off, the harder drug, once they're locked up, like their treatment is stopped cold turkey, and they're going to experience withdrawal and not going to have they will not have the support that they've had before. Like, it's incredibly disruptive on multiple levels. Um and yeah. So pretrial supervision is set up to be a trap for people. The idea being that, yes, people are out, but they need to be supervised on some level, to make sure that they're not getting in trouble. And yet, if they got in trouble, they would get arrested and they would end up back in the court anyway. It seems to be more of setting people up for failure and an excuse to charge people more money. And again, that money is not refunded in the event of an acquittal or a case dismissal, and it's not applied. There's no credit given to the person, if they are sentenced, which is interesting because you are credited for jail time. So let's say, for example, you were arrested and you were incarcerated for a month before you were able to post bail. And then ultimately you were sentenced, let's say, to a year. You have to do 12 months. That that month period that you stayed in jail during the pretrial portion of your case will get credited. So you would be it'd be the 12-month sentence minus the 1 month that you had already served, which makes sense and is something that is very right about the system. Like, you should get credit for any time that you were incarcerated. But the same doesn't apply to pretrial fees. Um, so if you paid any money, it's too bad. And get this, let's say that, you weren't able to pay everything and your case closes, or you were sentenced, or, you're no longer on pretrial supervision. Well, many counties and local places will still go after you for the money that you didn't pay. Maybe that was money related to these supervision fees. It was related to the ankle monitor. It was related to the drug tests, anything and all of the above. Um, and counties will use various methods to go after you to collect that money. Sometimes they'll send the money to collections, so you'll have like debt collectors coming after you. In some places, they will suspend your driver's license until you pay the money, which is super self defeating because if you don't have a driver's license, it's very hard for you to be able to do anything, much less drive to your job to make the money to pay off fees that you probably couldn't afford in the first place. Um, it can also impact your sentence because if you are convicted, oftentimes probation officers or whoever is the supervising agency for people who are sentenced will put together what is called a pre-sentence report or a pre-sentence investigation report, which is a report that they provide to the court with sentencing recommendations. And in that report, they can include how you did on pretrial supervision, and it can include whether you paid your fees. And so if everything from collections to impacting your to impacting your sentence, having your driver's license suspended, and other potential consequences can flow from you not being able to keep up with your pretrial fees. In addition to the fact, as I mentioned before, that you can be reincarcerated if you aren't able to keep up with your fees. And so there are massive sticks that governments use to enforce the financial interest in pretrial fees, um, and uh, and that is just at the very beginning of the case stage. So let's turn now to. We'll just start talking about this, and we'll get into it more in the next episode. For those who stay in jail, who aren't able to afford bail, or the court decided not to OR them, meaning release them on their own recognizance. For people who end up staying in jail, um, uh, they can stay there for a very long time, as we discussed. It can be anywhere from weeks to years that you'll be there until your case resolves. This is a huge leverage point for prosecutors. And what I mean by that is prosecutors will often use the fact that the person is detained pre-trial to coerce pleas, because prosecutors can charge whatever they want. Whatever they want. And I know you're going to say, well, no, doesn't it have to be tied to the facts of the case? Like, no, it's just not how it actually works. The, the prosecutors will often do this. It's called upcharging. Okay. So they will, if they decide, right, the police will file their police report and list kind of initial charges. And then the prosecutor's office is going to decide whether or not they're actually going to file formal charges. And that may involve an indictment, it may not. I think I'll have to do a separate episode about that. But anyway, prosecutors will then decide whether they're going to file formal charges. And prosecutors can list any charges that they want. And what prosecutors will often do is list a whole bunch of charges, and present to the person who is incarcerated the following. Basically, okay, well, if you plead to X today, you can get out tomorrow, or you can get out in short order. But if you don't plead to X, then, and you go to trial, you're going to go to trial on Y, which are these much, much higher charges. And you could be facing much, much more time in prison. So basically, plead to this lesser offense and you can get out today or very soon, or don't take the plea and face your trial, who knows how long down the line, and face much more serious charges with the potential for much, much more time in prison. And the prosecutor often is holding all the cards at this point as well, because in many places The prosecutor isn't required at this early stage to hand over all of their discovery. Like, the defendant doesn't even know what evidence the government has against them to be able to make an actually informed decision about whether to take this plea. A lot of people will take that plea because there's other pressing things in their life. They're like, okay, if I plead to this misdemeanor, even if I didn't do it, I can get out tomorrow, and that means I can get back to my kids. I can get back to paying, rent so I don't lose my home. I don't have to sit in jail longer. I can go back to my life rather than take the risk of sitting in jail for God knows how long to face charges that could put them in prison for decades. And again, they're not operating off of full information. The prosecutor hasn't handed over, like, well, here's your complete file, here's the evidence we have against you, and then you can decide whether to take that risk of, taking your case to trial. Many people will plead out as a way to get out of jail. And prosecutors know this. They know that many people can't get out because they can't afford bail. And so they're sitting in jail, suffering all of the consequences that come from just sitting in jail, strain on their family relationships, strain on their children, have lost their jobs, have lost their housing. Oftentimes, people's belongings and other things get stolen while they're incarcerated. Like if they were living in a motel or something like that, or on a campsite, like people will come and just steal their stuff while they're incarcerated because they're not there to oversee their stuff. Their children can be taken into foster care system because they're not home to care for them. There's so many horrible consequences that can come from being incarcerated. And so many people will make the choice of like, I'll plead to whatever this is just so I can get out, even if they didn't commit that crime, even though they didn't actually have a chance to see the evidence against them, because it's the government's burden um, to prove the case against you. And I think that that's something that is so deeply undermined by our criminal court system. Like, the quote unquote proper way is that the government has to present the evidence, and it has to meet their burden, right, of proof beyond a reasonable doubt that you committed the crime. But that's not actually how it plays out. Most of the time, the government just uses the leverage of you being detained pre-trial to coerce a plea out of you. Um, and um, so that it can be understood just how common this is, most cases resolve by plea agreement. And when I say most cases, I mean well over 90%. I think that TV and news in general, does a disservice in having people think that most cases go to trial and people have their day in court, and the evidence is presented against them and they're allowed to question witnesses. That is such a minority of cases. Well over 90% of cases at all levels are resolved by plea agreement. Actually, the criminal court system would come to a crashing halt if people's constitutional rights to a trial were actually respected, and everyone who had a right to a trial actually got a trial. The criminal court system would come to a screeching halt because they don't have the capacity um, to process that many trials. Pleas are used to process people quickly. And that is what prosecutors do. They process people quickly by coercing pleas out of people, using the fact that they are detained pre-trial as a key point of leverage. And a lot of people in that situation do that. And, uh, you might think that you wouldn't in that situation, but you'd have to put yourself in the shoes of someone who's in the system and is sitting in jail and has the option to plead out today and get home today, or risk spending God knows how long in jail until you can finally have a trial, and then be facing a lot longer in prison. All right, that's enough for today. Didn't get too far. We'll have to continue talking about the plea process next time. All right, thanks and talk to you then.